Chapter 11 is the most complicated chapter in the Bankruptcy Code. There's a lot to it, a lot of moving parts. The big picture goal generally, the so-called exit strategy in a Chapter 11, is to come up with a plan that the judge will confirm that makes the dealing with debts manageable over time. So if this couple is filed under Chapter 11, I think we can safely assume that the couple had too much income to do a Chapter 7, and the debts were too large to do a Chapter 13, and that's why they ended up in a Chapter 11. Now, unlike Chapter 13, in Chapter 11 you don't have to file a plan right away, but you do have to do a lot of stuff at the beginning of the case. So after we file the Chapter 11 petition, and there are some other documents including the list of the 20 largest creditors, some other things. Within 7 days of the petition date, we have to submit to the Office of the United States Trustee something called the 7-day package. And it's a fairly voluminous package, which gives, in essence, a CAT scan of what's been going on with the debtors pre-petition. We also have to prosecute a series of what are called first-day motions. Now, in spite of the name, they don't have to be filed on the very first day of the case, but they should be filed pretty soon. One of them that's near and dear to the attorney's heart is the application to be employed, because unlike the other chapters, the court has to approve the employment of the bankruptcy attorney. So there is the motion to employ, or the employment application. There are a lot of other first-day motions. One that comes up with some regularity is something called the cash collateral motion. And perhaps the simplest context to see what's going on is, suppose you have a rental property and you have a mortgage on that property. So each month you send in the mortgage payment, and you're using the rent that the tenants are paying you to pay that mortgage. Well, if you have a rental property, I'm willing to bet dollars to donuts that in the mortgage contract there is what's called an assignment of rents clause, which says that the creditor has a right to the rent that you're receiving from the tenants. Now, as long as you make those monthly mortgage payments, the creditor's never going to act on that. But technically, that money belongs to the creditor. Well, if you want to use that money for any purpose whatsoever, once you go into the Chapter 11 case, you have to get the judge's permission. And so one of the first-day motions is a cash collateral motion. You also have to file a motion for adequate protection of utilities, because you don't want the electricity and the water to be turned off. There are a lot of other first-day motions that come up, but that is another big chunk that has to be taken care of. There may be litigation that you're going to have to deal with. Maybe you've got a creditor that's claiming it owes a great deal of money, and you've put in the petition that the creditor owes a lot less, and you're listing it as maybe disputed, contingent, unliquidated. Well, you can be sure the creditor will file a proof of claim that contains information that is very much at variance with what you've put into the bankruptcy schedules. And so you may have to do a claims objection. As the debtor in possession in a Chapter 11, because there is no Chapter 11 trustee, you inherit not only the right, but the obligation to avoid any fraudulent transfers that have taken place and any preferential transfers that have taken place. So there may be a fair amount going on there where you're going to have to initiate adversary proceedings to avoid those transfers. Ultimately, your goal is to get a plan confirmed. So that's kind of a two-part step, or maybe I should say a multi-part step. You're going to submit something called the disclosure statement for the judge's approval. Now, the big picture goal of the disclosure statement is to give the creditors sufficient information, adequate information, so that they can intelligently evaluate the Chapter 11 plan before they vote on it. And that you submit to the bankruptcy judge for approval. Most judges are going to want you to simultaneously submit the proposed Chapter 11 plan. So the judge is going to review the disclosure statement and plan. If the judge says, I think this is adequate, then the judge will tell you to send those things out to the creditors along with balance for the creditors to vote. And then there'll be a date by which the creditors have to get their ballots back in. And if you can get the plan confirmed, terrific. If you can't, you may need to go back to the drawing board. Now, there are lots of additional layers going on here that I suppose we could talk for hours on end on some of this stuff. I will say there are multiple hearings that you have to attend. Shortly after filing the petition, you have to attend with some representative of the Office of the U.S. Trustee something called the Initial Debtor Interview, the IDI. And that usually takes maybe about an hour or so, and there you're trying to convince the representative of the U.S. Trustee's Office of the viability of your exit strategy so that the U.S. Trustee's Office doesn't seek a dismissal of the case. Sometime after that will be something called the meeting of creditors under Section 341A of the Bankruptcy Code. And unlike Chapters 7 and 13, in Chapter 11, creditors do sometimes show up at those meetings of creditors, and there are times when it can get just a wee bit heated. The judge will also have an initial status conference, in which at that conference, prior to the conference, you'll submit something called a status report that really lays out the history and where you're headed in the case. So the judge has a good picture of what's going on. Then the judge will set some dates, a timetable for the case. One of the dates will be the claims bar date, by which any creditors who want to must file their proofs of claim with the court saying, hey, this debtor owes me money, I want to be paid. Now, if a creditor agrees with the way the debt has been scheduled in the bankruptcy petition, the creditor doesn't have to file a proof of claim. This is unlike in Chapter 13. But if the creditor does file a proof of claim, there may be, as I said a little bit ago, a battle over that. Now, getting back to the confirmation of the plan. In confirming the plan, if all of the creditors, in a way that can be made precise, vote in favor of confirmation, the judge will confirm the plan. Perhaps I should take a step back and give you a little flavor of what it means that in a way that can be made precise. In a Chapter 11 case, we divide creditors into different classes according to the kind of debt involved, whether it's a general unsecured debt, a priority unsecured debt, a secured debt. There are different classes, and the Bankruptcy Code has an order that these debts have to be repaid. The idea here is best pictured with a fountain. I'm sure you've seen these fountains where there's a bowl and another bowl below it and another bowl below it. Out of the top bowl, there's a spout that puts out water, and then the second bowl gets no water until the first bowl fills, and then the water spills into the second bowl. The third bowl gets no water until the second bowl is full and it spills out, and so forth. That image is a way to view these various creditor classes. The Bankruptcy Code has a list of priorities. The top priority has to be paid in full before the next priority gets paid, and so on down the line. Now, each class then gets to vote. Well, each creditor in a class gets to vote. And you have to have a class voting in favor of the plan. Otherwise, that class votes against it, and that's a non-consenting class. And it has to be 50% in number or 2/3 in dollar amount. If the class votes in favor of the plan, great. If the class doesn't vote in favor of the plan, you can still get the plan confirmed if at least one class is a consenting class. But that triggers something called the absolute priority rule. This is a very sharp sword on this one. So let's go back to the fountain for a second. What is the bottom bowl? The bottom bowl is the debtor. So the creditors have to be paid in full before the debtor gets anything at all. Now, if all the creditors vote in favor of the plan, you got no problem. You get to keep all your stuff and make those payments to the creditors once the plan is confirmed. End of discussion. But if you decide to do what's called a cram down, because you have at least one consenting class, but you have a bunch of non-consenting classes. What that does is it says all the classes have to be paid in full before you get to keep anything other than your exempt property. So if you've got non-exempt property, you will lose it. It goes into the bankruptcy estate for purposes of liquidation to pay creditors. And the only way you get to take it back is by adding new value to the estate. In essence, you have to buy that thing back. So you might have to buy your own house back. As a result, you want to be very careful about going into a Chapter 11. It's very powerful as a bankruptcy tool, and if you can get the plan confirmed, it can give great relief. You can spread the paying off of debts over a long period of time, and it buys you a lot of time. But if you can't get the plan confirmed unless you do a cram down, you could end up losing assets. So Chapter 11 is a great chapter. That's what happens when a couple files for Chapter 11, but it's a dangerous chapter, and you really don't want to do this without a very good bankruptcy attorney guiding you through it.